Our next speaker is Professor Lise Kjaer from the University of Copenhagen, and she has a distinction that we see very rarely and only in the most distinguished situations in the United States, which is she is a professor of law on the faculty of law at the University of Copenhagen. And where did you get your law degree?
Nowhere.
So occasionally we see, we don't have any linguists on law faculties without law degrees, but we do have psychologists, 3 or 4 of them, just in very unusual situations. And one thing that we've been seeing from people trained in linguistics and related fields, Jan and Isolde and now Annalisa, is enormous sophistication with the legal concepts, and that is they are largely self-educated with respect to the most sophisticated legal issues and trained in the language issues in order to ask questions about how, when you know this much about language, the legal system can be worked so that it's more human, because language is about being human. So I'm not going to list Annalise's publications, but you should hurry some of them up. There are lots of them. A very distinguished career as a legal linguist in many respects, especially issues of multilingualism here in Europe. So Lise Kjaer.
Thank you very much, Larry, for this introduction, and for the introduction also to the group that we are somehow represented in this room. And thank you also, Werner, for inviting us to this exciting seminar. And each time I listen to a new talk, I get the idea of another talk that I might have given instead of the one that I have prepared. So, but I wanted just to say, in continuation of what Larry just mentioned about my background, that as a linguist at a law faculty and as a professor of law with a linguistic background, I have been in discussions like the one that we just had many times. It is my daily work, I would say, to somehow convince people that linguistics indeed is valuable. I would say that they finally got it when they started to get interested in doing empirical legal research, because then all of a sudden lawyers found out that you cannot study law without studying language, and once you are going to do empirical legal research, you have to start with the data. And the data are texts, language, words. So that's just as a beginning. And I'm actually going to do something quite different and a little complicated in a sense, because I'm going to give a broad outline of what I have been doing and what I am doing and what I'm still in the process of doing or will do in the future. Because we are at a center called Recht als Kultur, I wanted to mention that I was deeply involved in the law and culture movement established also by Pierre Legrand, whom you mentioned earlier on. But today I have moved from that point, starting point, into another way of looking at law and language, looking more like on the discourse of lawyers in international law. And I have identified within the past couple of years the intense involvement and intense use also of effectiveness as a key word in modern legal language, and that is what I'm going to address mostly today. And I'm going to do also a little bit of a presentation of empirical legal research or legal linguistic research that I have made on the notion of and the linguistic expression of effectiveness in the case law of not both of the courts, because I haven't got time to do it, but the European Court of Human Rights. And in that sense, you could say that I'm the next step, because you talked about the Charter, and I'm going to focus mostly on the European Court of Human Rights. So my first step in this also trajectory, in a way, of my research would be then law and language in the light of European legal culture. We know, all of us in this room, that the interdependency of law, language and culture causes difficulties of translation between legal languages, and also from a more legal point of view of harmonization of European legal systems. And those difficulties, and Isolde has focused mostly on the first part of it and what consequences that difficulty has for legal interpretation. European legal lawyers have been very much interested in finding out how you can cope with the difficulties of the multiplicity of legal cultures, and in the midst of having the desire and the end goal of establishing uniform law. And this has then given rise to somehow establishing also a common legal language in Europe. And this can mean both, of course, and has been addressed by European lawyers in diverse European countries, including Germany. A conceptual language could also mean a linguistic, in the sense of a language, in the sense of a legal lingua franca. So, and it's so. I'm happy that that you mentioned Pierre Legrand. I thought that you might know him. Of course, you do. The convergence debate, which was very heated. It's not that heated anymore, but it was at the time in the 1990s, with Pierre Legrand as a Canadian, French Canadian, who was competent in both, is competent in both French law and English law and English and French languages. He had this. He somehow addressed this from his point of view, rather superficial and naive idea of establishing a common European Union law in the midst of the diversity of languages and cultures. And he famously, in his article from 1996, stated that the whole idea of convergence of legal systems is misleading, because the mentalité of the civil law legal system and the common law legal system are so different that you cannot really bring them together. That was his idea. Is his idea. His not as engaged in that debate anymore, but of course he is still very much the person and the scholar who is famous of bringing this convergence debate into existence in the 1990s. So I mentioned that only briefly. I have written about it, and I'm also only mentioning this idea of autonomous concepts, which Isolde also shortly mentioned, because that was somehow, the response, not to Pierre Le Grand, but the response of the European Court of Justice to the diversity of legal cultures and legal languages, in the sense that in its famous Costa versus Inel judgment from 1964, they said that any attempt to explain the contents and nature of community law on the basis of national law precludes community law from being conceptualized as an intrinsic unity, thus depriving of it of its community character and challenging its raison d'être. And in many other later cases and judgments, they would then refer to the idea that concepts used in EU legislation must be interpreted as autonomous and uniform, autonomous concepts of EU law, and given an autonomous and uniform interpretation without reference, unless it was stated that way, to the member states' legal concepts. And the same holds true for the European Court of Human Rights. And we have George Latzas, whom some of you might know, and English you do, I believe, legal scholar, who wrote a book on the theory of interpretation of the European Convention on Human Rights, and somehow defined autonomous concepts, similarly to those in EU law, as concepts that enjoy a status of semantic independence from the meaning that the same concepts possess in domestic law. And you could say and dwell on that, and that's really interesting also to reflect on what does that mean. I'm not going to do that. I'm sure that perhaps in a way, not directly, but in a way, the way that you're going to talk about EU law might somehow be a hint to what to do about it. And there's an example which I find is interesting also in explaining the whole idea of autonomous concepts, where we had a case in 1999 before the Court of Human Rights, where the court would have to find out whether a French legal association, municipal hunting association, would be an association within the meaning of the European Convention on Human Rights. And of course, the French government had then given, and the parties had given their understandings of what an association would be. And then the court stated the question is not so much whether in French law ACAs are private associations, public or para-public associations, or mixed associations, but whether they are associations for the purposes of Article 11 of the Convention. So that is the whole idea of an autonomous concept, the semantic independence from national law. So the other aspect of, the problem of having the diversity of legal languages and legal cultures would be then to say, and we discussed that briefly before we started the conference, that, well, we might introduce a lingua franca, and then all of a sudden we would solve all problems. And we could also say that, in a way, what is happening is that European legal actors actually do interact increasingly across both legal and linguistic barriers, referring to the same European legal sources and the same case law from the two common European courts. And in that sense, in a way, their understanding of concepts, also the national concepts, are starting in a way to converge. And they do that increasingly also in an international legal English with no reference to the English common law system as a lingua franca. And that's why, as a parenthesis to that, I believe that even without the UK in the EU, I still believe that we are going to use English. There might be a power struggle about it, but I think that in the end we are still going to use English as a lingua franca, and that we will also stick to multilingualism because it's a powerful idea. Okay, my next step then in this development of my thoughts is that, well, I have noticed, as I mentioned in the beginning, that effectiveness somehow penetrates not only, discourse, modern discourse in general, but also actually both academic and judicial legal discourse. So I find effectiveness to be a key concept in 21st century discourse. And there are two ideas. It seems to me that 21st century international English, could also say 20th century, but it's about, it's late 20th century, starting 21st century. International English is strongly influenced by neoliberal discourse, and that neoliberal discourse seems to have influenced European legal discourse as well. I had difficulties in inserting a title to that figure, but I can explain what you see. This is from the N-gram viewer of Mark Davis at the Brigham Young University, who made a more searchable version of the Google N-grams. So it is based on Google N-grams data, but it is taken from Mark Davis's corpus. And what you see here is American books and their use of effectiveness and effectively, and so on. And you can see a steep rise, and then it's somehow leveled out closer to 2000 in the use of effectiveness. Also relatively, and that's important, relatively, it's a steep rise. This is the British version. That's even more clear that there is a steep rise. I'm thinking about Thatcher. I don't know why, but it might be an explanation. I haven't digged into that. That's why there's so many aspects of this research and that you could dig into. So, and now I jump to the statute of the European Commission for the Efficiency of Justice, which was set up in 2002 by the European, the Council of Europe Ministers of Justice. And I think it's interesting that they set up a commission for the efficiency of justice, and especially when you dive into what they say about it. The aim of the European Commission for the Efficiency of Justice is to improve the efficiency and the function of the justice system of member states with a view to ensuring that everyone within their jurisdiction can enforce their legal rights effectively. So far, you might just notice that that kind of language occurs in that kind of document in our present time. on the Commission's website, you can see more clearly the kind of language. There's general conventions here that can explain the difference. In setting up the European Commission for the Efficiency of Justice at the end of 2002, at the initiative of the European Ministers of Justice who met in London 2000, the Committee of Ministers of the Council of Europe wanted to establish an innovative body. We're talking about a commission under the Council of Europe for improving the quality and efficiency of the European judicial systems and strengthening the court users' confidence in such systems. And that's linked actually back to your discussion about trust. But it's really, from my point of view, interesting that we talk about also court users, not citizens, but court users. It's very instrumental. We have the same kind of language in contemporary academic legal writing, and this is a draft, a quote from a professor who's an expert on international law, Journée, and he's written a book. This was his working draft, but it's pretty much the same in the end version. Assessing the effectiveness of international courts, can the unquantifiable be quantified? And again, the increased centrality of international courts in the life of the international community invites, however, a critical assessment of their performance. Are international courts effective tools for international governance? Do they in fact fulfill the expectations that have led to their creation and empowerment? Could results of equal value as those produced by international courts have been generated by other, less costly or time-consuming mechanisms? So this is, the kind of language also used by many academics, not only him, by many academics, also some of my really dear colleagues at the Center of Excellence for International Courts, because we are measuring how international courts perform in different ways and from different perspectives. And in line with the trust and perhaps lacking legitimacy of international courts and European courts, you have also, judges, presidents of the courts, addressing their effectiveness increasingly in their annual reports. I did research on that as well, but I just wanted to mention that they increasingly use the notion of effectiveness in their annual reports. And there is, of course, reasons why they do that, and why they do that increasingly, because of the caseload that they have to somehow manage to get rid of. But it's definitely also a push from the member states that the court should be more efficient and effective. Come back to that. So I don't want to dwell into each of each of the annual reports, but just also mention that this is definitely, a kind of language that the presidents of the court in their annual reports have adopted. And then I look back in history, because this is the statute of the Council of Europe, the preamble, first and second recital, where the governments of the 10 states that set up the Council of Europe have decided to set up the Council of Europe, convinced that the pursuit of peace based upon justice and international cooperation is vital for the preservation of human society and civilization, reaffirming their devotion to the spiritual and moral values which are the common heritage of their peoples and the true source of individual freedom, political liberty and the rule of law principles which form the basis of all genuine democracy. That kind of language somehow has disappeared. Of course, it is in the text still, and the texts are still, in force and so on and so forth. But you will see in a moment, and it would be really, really interesting, and perhaps it's all the two of us should look into that, because I would really want to know in more detail what has happened to the French legal language. I have identified that there's a spillover effect from the English effectiveness language into the French language versions as well. But that would be really interesting. We might do a small project about that. So we had in the preamble to the statute of the Council of Europe, all genuine democracy that I just mentioned. Already in the preamble to the European Convention on Human Rights, which was set up a few years later, you have in the English version the use effective political democracy instead. And it's really interesting, in the French version you still have the genuine democracy idea, but in the French version, in the English version already at that time you had effective political democracy, and when you compare the language version, I don't show it here, you will see that some versions in the beginning were translated from French and some were translated from English. And when you do the comparison across time, you will see that the effectiveness language has penetrated all language versions. The English version is now somehow the guiding version. And then the question, of course, arises. We saw that the president of the court uses effectiveness language in his annual reports. What about the judgments? This is the development of effectiveness cases over time. European Court of Human Rights. The first many years are not as reliable as because there are very few judgments. So what is really interesting is what is happening as from about 2000, and you then see this steep rise again in the use of effectiveness and effective in the case law of European Court of Human Rights. And this is the similar development of the use of effectiveness European Court of Justice. So there's definitely something to look at here, and the thing is, the question then is, what is it? What does it look like? What are the of course some of the effectiveness uses are already inherent in the convention text, because it is one of the core rights is that every citizen has a right to an effective remedy before a national authority. And in a case from 1996, we have then the court reflecting on the notion of torture. That was why I mentioned that also, and whether or not you should interpret Article 3 about torture in connection with Article 13. And yes, it's stated, and it has been then established in case law, that in order for investigation to be effective, you need to to include the notion of effective remedy, so that you would say that thorough and an effective investigation capable of leading to the identification and punishment of those responsible, and including effective access for the complainant to the investigatory procedure. And this is continued then, because then the court actually refers to another convention, the UN Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment, Punishment, which imposes a duty to proceed to a prompt and impartial investigation. So this is a different, more specific, declaration, you would say, of what, or explanation of what is meant by effective investigation. So the European Court of Human Rights then concludes such a requirement is implicit in the notion of ineffective remedy. But why did the European Court of Human Rights then choose effective investigation? Why not real, genuine, thorough, or why not prompt and impartial as in the other the Torture Convention? So I've had a more close look into the effectiveness case law of the European Court of Human Rights, and have found out that the lemma effective, in all its then linguistic varieties, is applied in 7,726 judgments, including 387 grand chamber judgments. And those are the English versions. And especially if you compare the number of grand chamber judgments with the total number, which is only 444, you'll see that in almost all judgments you will have somehow a notion of effectiveness or effective addressed in the judgment. Effective remedy is not. Those are really only examples that you can get an idea of what I'm talking about. Effective remedy is in the convention text. Effective domestic procedures would be also one of the noun phrases. Effective legal assistance, effective legal representation, the effectiveness of its defense, effective participation in the proceedings, effective access for the complainant to the investigatory procedure, providing with an effective opportunity to participate in the hearings, and again, effective in investigation, as I have already talked about. So some of them are really peculiar. An effective opportunity to participate in the hearings. But somehow, you wonder why. It's also really interesting that somehow the court, in the drafting of the judgments, not only in the drafting but also in the final versions, of course, tend to use binomials. So you have practical and effective, which is almost a core concept of the court's case law. Effective and adequate, effective and confidential, accessibility and effectiveness, appropriate and effective, effectively and expeditiously, meaningfulness and effectiveness, prompt and effective, real and effective. So sometimes, you would wonder why they seem, in all cases, to feel obliged, or to add effective, or on the other way around, why they feel obliged to do something else as well. You can have several explanations for that. We can discuss that afterwards. It's also various verb phrases. It is all over the place, but you could say again, in a case of habitual or expulsion, you would have this peculiar instance of, I don't know how to point, so I'm pointing with my finger, the one here, a country of habitual residence to which he is effectively entitled to return. And if warranted, consequent measures for redress could then be effectively adopted. So I would say there is an overwhelming interest in applying not only the linguistic phrase or the word effectiveness, but perhaps also, the notion of effectiveness. Because you have also, the court defining then what it means by effectiveness. In order for a remedy to be effective and to avoid any risk of an arbitrary decision, there must be a genuine intervention. To provide an effective remedy, the appeal must be suspensive of the expulsion. It remains for the court to determine whether the means available to the applicant in Polish law for raising a complaint about the length of the proceedings in this case would have been effective in the sense either preventing the alleged violation or its continuation, or providing adequate redress. And you can see here the highlighting also of effective. And now I have multiple conclusions actually to this talk, but one conclusion could be that effectiveness in a way has achieved the status of an autonomous concept in the case law of the European Court of Human Rights. So we meet the standard of effectiveness of the purposes of Article 13. Again, this is a quote also from that I mentioned before. The Commission's findings would indicate strongly that the test for effectiveness. So we have a standard, we have an autonomous concept of effectiveness, which might be derived from the same kind of language that we identify in neoliberal discourse, but somehow is adapted and adopted to the legal context. I say our research because I'm working together with Lise Kjaer on this, and she is doing research on the European Court of Justice on effectiveness, and I have them specialized on the European Court of Human Rights. We found out that effectiveness as a key concept of neoliberal discourse has penetrated both academic and judicial discourse on international and European law, and that the use of effectiveness has increased in the case law of both European courts, as it has indeed in general language, and that the legal meaning of effectiveness has been expanded, if not changed, over time. So that would be my talk. So questions, comments, anything that might enlighten the research and what we are doing, I'd be really, really grateful.